Mr. Desmond Choo.
Mr. Deputy Speaker, sir, thank you for allowing me to join today's debate on the bill. The changes in consumer behaviour and the nature of service provision require that our small claims tribunals evolve its reach and jurisdiction to remain relevant as another arm of consumer protection. There are two major changes in consumer behaviour that will make evolution of the small claims tribunals timely. First, services are increasingly being performed by freelancers in the gig economy for companies. For example, the media and tour guiding industry are dominated by freelancers. They do not have the security provided by the Employment Act, and some use the small claims tribunal as a main recourse to pursue unpaid services or when disputes in the provision of services occur. Therefore, the increase in monetary value of claims and the adoption of judge-led proceedings will help the freelancers. This is especially so as the monetary value of the services increase over time. I also suggest that the Ministry can work with the tripartite partners to develop industry-specific claims mechanisms to help our freelancers. While the claims process has been simplified over the years, the process can be intimidating for many freelancers. For example, the process requires the person to identify the breach and evidence it in writing. This can be intimidating, especially for those less acquainted with the legal process, as also brought out by Honourable Member Mr. Patrick Tay. And our freelancers may frequently come up against larger companies which have access to legal counsel, though lawyers cannot be present during proceedings. Establishing industry-specific claims mechanism for freelancers may help to level the playing field. For example, the SET can mandate certain cases to be mediated by the tripartite partners with consensus made enforceable by the SET. This process is important in establishing new longer-term forms of protection for Singaporeans joining the freelance industry. This is also an expanding part of the Singapore workforce that operates outside of the ambit of the Employment Act. The Small Claims Tribunal can form a key thread in the fabric of support. The other significant change to the consumer landscape is the fast growth of microtransactions involving larger groups of consumers. For example, there are many disputes involving customers who purchase items through Facebook or Carousel, and where the expected services are not rendered properly, they lead to disputes. In such instances of microtransactions involving multiple parties and claimants, it is often not economic feasible for the individual to file such claims. However, does the SCT allow for a larger group of consumers to file for such claims collectively? The evolving nature of online retail is such that many consumers can be affected very quickly over a very short period of time. Perhaps the Ministry can consider for such collective action without everyone having to file individual claims, as perhaps also expounded by the Honourable Member, Mr. Murali. The SCT was set up in 1985 to provide quick and inexpensive forum for the resolution of small claims between consumers and suppliers, as stated also by Honourable Member Mr. Chris D'Souza. While the costs of filing claims in SCT are affordable at 1% of the claim amount for consumers, this cost quickly escalates in the enforcement of the claims. From the perspective of the claimant, having a judgment without enforcement defeats the purpose of filing a claim. Should the other party resist compliance, a writ of seizure may need to be issued, and the administrative and ancillary cost may come up to $400 to $600 easily. Or the claimant can appeal to the registrar to waive or defer the payment or claim the cost from the judgment. It is not guaranteed to happen. Consumers will weigh the cost and benefit and feel that perhaps it is not worth the time and money over a claim, as the original claim amount could be lower than what you have to pay for enforcement. The process could also be complex and may take some time. Hence, consumers may just give it up if the amount is not large and the cost outweighs the benefits. Rogue business owners or service providers may then be able to get off scot-free. We must guard against these businesses hiding behind the veneer and cost barriers to law enforcement. Consumers must also be made aware of the difficulties of enforcing claims at the time of purchase rather than at the point of making claims. Mr. Deputy Speaker, please allow me to continue in Chinese. 副议长先生，通过扩大小额索偿庭的司法权和加强索偿程序，有利于方便更多人寻求司法途径解决问题，也让索偿案能更快速审理。这加强了消费者的购物保障，这也对自由业的国人的一种保障。对很多国人来说，对很多年长或没有法律经验的国人，法律程序是懊恼敬而远之的。我尝试体验索偿程序法律时，发觉到有时用词和程序的确需要一段时间去思考，才能真正了解如何去处理。对没有接触法律课题的国人来说，这更会形成显著的障碍。我希望律政部能继续简化索偿程序，尽量简化法律用词，特别是在执行索偿庭命令时简化流程。Mr. Deputy Speaker, sir, the changes to the SCT must occur to reflect its relevance in the new norms of consumer behavior. At the same time, it must strike a careful balance between inadvertently fostering a litigious society and consumer rights. Mr. Deputy Speaker, I support the bill.